Good afternoon and welcome to the Rapid City Legal and Finance Committee meeting for August 12th, 2015. And I'd like to start the meeting with a roll call and determination of quorum, please. Thank you. Now's the time to adopt the agenda. There is a request to move an item. Chair recognizes Alderman Nordstrom.
Thank you, Madam Chair. If we can get approval to move item 19 to follow item number 25.
Is there any objection from any seated committee member to move item number 19, which is a supplemental appropriation number 3, to after item number 25, which actually is an item that contains a portion of money that is being moved or being taken care of in supplemental item number 3? Any objection?
Move to adopt the agenda.
Got a motion by Nordstrom to adopt the agenda, moving item number 19 to directly after item number 25 on the agenda, second by Laurenti. Any further discussion? Seeing none, all in favor? Aye. Any opposed? Agenda has been adopted. Now's the time for general public comment. This is a time for any member of the audience to direct concerns or comments to the seated members on the dais this afternoon. This is concerning any items that are currently not on the agenda. I do have one public speaker request for public comment. Jackie Giago. If you could approach the podium. Oh, Jackie, are you referring to item number 19? 19 is a supplemental appropriation. So the finance officer is commenting that your comment may be directly related to the 2016 budget, which would be item number 20. Is that correct?
Introduction first reading ordinance regarding for 2016. I would believe that's what I'm looking for, yes.
Do you mind if we go ahead, because that is not on the consent calendar, which means it will be an item discussed by itself? Do you mind if we put you to that item and we can hear you when we get to item number 20?
Sure.
All right. I currently have no other speaker request forms for general public comment. Am I missing anyone that would like to speak on any item currently not on today's agenda? Seeing none, general public comment is closed. We'll move on to public comment for consent items 1 through 17. Are there any public speaker request forms for consent items 1 through 17? I do have one speaker request form, but it is just from Mr. Dick Johnson, and he is available for any questions on item number 6 if committee members have any questions. Other than that, seeing none, public comment is now closed. We will now have the committee members discuss or entertain a motion to approve consent items. Chair recognizes Alderman Laurenti. If you'd like to pull any items.
Thank you, Chair. I'd like to pull items 2, 5, 9, and 17. Thank you.
Chair recognizes Finance Officer.
Thank you, Madam Chair. Can you please pull number 6? I want to clarify the contract with you.
And Chair recognizes Alderman Nordstrom. That's got him.
Thank you for the delay, Madam Chair. I'm just kind of double checking. I think we've got everything pulled that needs to be.
All right. Thank you. Now I'll entertain a motion to approve the balance of the consent items, which is 1 through 17, except items number 2, number 5, number 6, number 9, and number 17. Alderman Lewis, do you make that motion? I've got a motion by Alderman Lewis, second by Drew, to approve the consent agenda items 1 through 17, except 2, 5, 6, 9, and 17. Any further discussion? Seeing none, all in favor?
Aye.
Any opposed? Items have been approved. Item number two. Item number two is to authorize the mayor and finance officer to sign joint powers agreement with Pennington County Sheriff's Office in the state of South Dakota for police psychologist services. Chair recognizes Alderman Laurenti.
Thank you, Chair. And if I can, I'd like to ask the Attorney's Office a question on this or two.
I don't know if we have a representative from the city attorney's office present at this time.
I know he was just here, so.
All right.
Back. Well, while we're waiting, I have a question for Finance Officer as well, please,
All right.
regarding this matter. But my question is this something that's budgeted for the 2016 budget? Where are we at, Pauline, on this? Can you tell me? And the city's portion of it as well.
What I know about this agreement is that it is an agreement that basically we're continuing services with what we have now, and services are split. I think it's between 3 or 4 different agencies. It is budgeted because it basically is just a renewal of an already existing agreement. That's what I know. Dollar amount wise or percentage wise, I'm not sure what the city pays. Perhaps Captain Rude could help us if he knows.
This isn't a new position.
No.
Okay. That satisfies me there.
No, we've several years now. It's a joint, this is just an annual agreement update or renewal.
Okay, I appreciate that. And maybe for expedition, let's move forward. And
All right, I'll entertain a motion to take some type of action from a seated committee member on item number 12, or item number 2, sorry about that. Alderman Lewis made a motion to approve item number 2.
Second.
Second by Nordstrom. Any further discussion? Seeing none, all in favor?
Aye.
Any opposed? Motion carries. Item number 5. Item number 5 is to authorize the mayor and finance officer to sign the life safety loan agreement between 10 Sleep LLC and the city of Rapid City. Chair recognizes Alderman Laurenti.
thank you, Chair. And again, if I may, with the finance officer, Pauline, on this particular issue, which I supported the life safety loans, but my question to you is from SAB. And I think I've visited this before, and I can't remember exactly what it was. We were doing a loan again, but I think I have the same questions I did a couple of years ago, which was, are we pulling credit on these people? Do we have any idea of their credit worthiness?
We are not doing a credit report on these individuals. However, we do require a letter of credit from the banks. So basically, a bank is actually taking the risk. So if they don't make their payment, we can pull their letter of credit, and the bank will pay us, and then they will go after the owner to repay them.
So there's a guarantee by the bank for the full amount of the loan?
Correct.
And who determines the interest rate?
That is actually in our ordinance. It is a 2% interest rate currently. However, they can present proof of how much their letter of credit cost them at the bank and get that credited back to them after their first year.
Yeah, I was hoping that we would actually be charging more, since that is something that's a positive for the city. 2%, that's an unbelievable loan. I mean, I don't know what you would get if this individual or this LLC had to go commercial, what they would have to pay, but my guess is it would at least be 5.
Correct.
Just-
We've revised this ordinance multiple times, and I think this is the third type of interest rate that we've done. They were telling us when we first started that the interest rate was, between the interest rate and having to provide the letter of credit, it was cost prohibitive to do that. I do know that one of our businesses, that they actually have 2 loans out for 2 different locations, they did provide proof of what it cost them to get their letter of credit for each of those loans, and it was about $1,000 a piece. And like on their loans, we're talking $14,000 and $18,000. And that's on an annual basis. So between the 2%, or if it were 4%, plus that letter of credit guarantee, it would have been easier and cheaper for them to go to the bank. And so we wanted to give them a little more incentive to go ahead and put in the sprinkler systems and work with them so that it was beneficial to both the city and to the property owner.
So who is reimbursing the cost of the guarantee?
After the first year, we will credit back the next year's interest up to the cost either the cost of the letter of credit or the interest amount in full, but never will they have a credit going into another year. So they will always pay us 1 full year of credit and possibly additional, or of interest and possibly additional interest. I will tell you the gentleman who provided the 2 loan amounts, or the guarantees, it will be no interest for the second year for each of those loans. And so it really is just an incentive,
So is the reimbursement part of the ordinance as well?
correct?
Okay, maybe that's something we need to look at. I think we could do better. I mean, they're still going to get a great deal if we bumped it to 3.5.
We do currently have 4 loans outstanding. This would be the 5th, I believe.
And have we had any issues with repayment?
Not yet.
Okay, thank you.
And just for clarification, the item number 5 being discussed, this life safety loan, is a loan with the city that businesses can apply for in order to put a sprinkler system into their buildings. It generally applies to and helps out the fire department with their safety side of the buildings. So thank you for the discussion. I'll currently entertain a motion on item number 5 from a committee member. Got a motion by Nordstrom to approve item number 5? Second by Alderwoman Drew. Any further discussion? Seeing none, all in favor? Aye. Any opposed? Motion carries. Item number 6 is to authorize the mayor and finance officers to sign the electric cooperative revenue agreement between the City of Rapid City and West River Electric Association and Black Hills Electric Cooperative. Chair would like to recognize Pauline Sumption.
Thank you, Madam Chair. The original agreement that was attached to the agenda was for a 5-year agreement, the first year being at 1% and the last 4 years being at 0.75% of gross revenue. In visiting with council members Monday morning, as well as Mr. Johnson with the Electric Association, we decided to bring forward a 1-year contract instead for 2016 at the 1%. That I put in front of you on the dais for your review, and that is the one that we request that you actually approve. This will allow Mr. Johnson to visit with Mayor Allender moving forward, and then possibly looking at a 5-year contract after that.
Thank you. Do any committee members have any questions? If not, I'll entertain a motion by a committee member. Got a motion to approve a 1-year at 1% contract on item number 6 by Alderman Laurenti, second by Nordstrom. Any further discussion? Seeing none, all in favor? Aye. Any opposed? Motion carries. Item number 9 is to request the transfer of $25,000 from the general fund to the educational loan fund. Chair recognizes Alderman Laurenti.
Thank you, Chair. And since Chad is no longer the chair, and I appreciated his service as the chairman, but he moved a little faster. I didn't get much opportunity, so now I feel like I really have to make up for it. But I'm kidding, just kidding. So a question on this particular item as well, because it states something about the fact that this particular, and I'm going to direct this to the finance officer, and because Jeff is not here. But my question, because there's something stated in the attached or on part of it, is that we've depleted the funds. But my question then is, if we've depleted the funds, are we not getting paid back? How soon do they have to wait till they've completed whatever educational requirement before they start paying? Where are we at with that? Why are we depleted?
Well, I will tell you that we are getting money back. We receive about $1,500 a month in repayments. They start paying back immediately after getting the loan. For lack of a better term, what the issue is people are actually taking advantage of this now. We have more and more people going back to school trying to further their education, and this is a low cost. Basically, they get a 1% interest up front, and then they have up to 2 years to pay the loan back. And so because we've had more and more people that are taking out the loans, the repayment is not coming in as fast as people are taking out loans. And so we just need to up the cash amount, and then eventually it'll become a revolving loan fund for that educational purpose.
One last question for you. Now I've lost my train of thought. Give me a second here. That's right. It must not have been that important. Thank you.
Chair recognizes Alderman Nordstrom.
If it's all right, Alderman Laurenti, I'll give you a couple seconds there to kind of think about your question. Just an FYI for the council members, when I was in the rank and file, we had several people take advantage of this loan opportunity, and it was utilized, and the best of my knowledge, all of that was paid back in full and on time, and so everything was worked out real well. So if we need to augment this line item, I can really support this. So hopefully Alderman Laurenti kind of thought about what he needs to present.
And just a clarifying comment on item number 9 is that when I first asked a question about it, I thought it was a line item budget. It is not. It is actually, once this transfer makes, it's like putting it into a separate account, that account should take care of itself, and staff had recommended that once this $25,000 transfer is made, it will probably last for several years again, especially with the payback period. Chair recognizes Alderman Laurenti.
I remembered. Thank you for that opportunity, Alderman Nordstrom. But my question for the finance officer again is, because it's been depleted, is this basically a supplemental, and what cost center holds this particular?
This one is Alderman or Alderwoman Scott actually kind of addressed this. It has its own separate fund, so we already have $30,000 a year budgeted in the educational loan for people that want to take out a loan for their education, whether it's the class or the books or whatever. So this is actually just a cash transfer, transferring cash out of the general fund and putting it into the educational loan fund. So basically moving it from one checking account to the other.
So is it undesignated cash, or?
It is undesignated
Okay.
cash from the general fund.
That's what I wanted to know. Thank you.
Seeing no further discussion, I'll entertain. Chair recognizes Alderman Nordstrom.
If the motion hasn't been made, I'll make that motion to adopt.
Got a motion by Nordstrom to approve, second by Laurenti. Any further discussion? Seeing none, all in favor? Aye. Any opposed? Motion carries. Item number 17 is to authorize the mayor and finance officer to sign the debt modification agreement with Pioneer Bank and Trust. This is regarding a loan. Seeing no lights, I'll go ahead. No, I actually, some clarifying information, Alderman Lewis. The staff discussed this on Monday morning coming forward. This is a proposal for $38,000, a balloon payment from the Parks and Rec Department that needs to be made based on a loan agreement that was taken out roughly about 5 years ago. And so the discussion was, for $38,000, why wouldn't the city go ahead and loan itself and be able to collect that interest rate on such a loan payment? And so the discussion was held that we would have this discussion today and possibly recommend to the city council Monday night that we initiate the loan internally, pay off the $38,000 balloon payment, and have the Parks and Rec Department pay back the city general fund the 3% that they were going to be paying the bank. So with that clarification, if any other committee member would like to weigh in or make that motion, it would be appreciated. Chair recognizes Alderman Laurenti.
I'd like to make that motion, but I'm not sure what the motion will be, so maybe the finance officer can help us with that as well.
Chair recognizes Pauline Sumption.
Thank you, Madam Chair. The motion would be to approve an interfund loan between the general fund and the Meadowbrook Development Fund, and the amount needed to pay the loan in full, interest rate 3%, repayment period 2 years.
So moved.
I've got a motion by Laurenti, a second by Drew. Does the recorder need any clarification, or does the recorder have the motion as specified by the finance officer? Maggie? You got it?
I'd like to maintain
Perfect.
the floor.
Chair, Alderman Laurenti, you still have the floor.
As a matter of truth in lending on this particular issue, I think we need to, at least state that we're not actually reducing the interest rate, we're actually increasing it, because it should be paid right now and it should be at zero. So, we're looking at 3% on $38,000 over 2 years. I don't know, about $1,200 more, I would guess, $1,100 to $1,200 more we're going to have to pay for that money. When my question and I have a question with the finance officer, if I can, please, on this issue. Because it was a 5-year loan initially, the balloon payment, and I've seen this before, we have these balloon payments, but It's never budgeted, the balloon payment. We never anticipate paying it off so that we can avoid the additional interest.
Quite honestly, when we took out this loan 5 years ago, it was refinancing the loan from somewhere else at the time. And state statute says a regular loan can only be for a 5-year period. So going into this, we knew that there was possibly going to be a balloon payment, well, not at the end of the year, or we could refinance it for an additional term. 5 years ago, we knew going into it today that we would probably refinance that balloon payment for an additional however number of years that we needed to. There was talk about reducing the interest rate. What they're paying now is over 4% to Pioneer Bank, and they were offering 3% on this restructure agreement, and the discussion Monday was, well, how about a 2% instead? But then the other part of the discussion is, why would we lower the rate? Why not pay ourselves? Because honestly, it's money that we're taking out of our account then to pay it, and so we will lose the interest that we would have earned at the bank by paying the loan off now.
So what is the source of funds going to be for this inter-city fund?
Loan? It'll be undesignated cash from the general fund.
Okay, thank you.
Seeing no further lights, I'll entertain a motion on item, I guess I already have a motion and I have a second. Any further discussion? Seeing none, all in favor? Aye. Any opposed? Motion carries. That takes care of the consent items 1 through 17. We are now on to non-consent items 18 through 26. This is the time, Jackie, that we can go ahead and address the public comment for item number 20. If you want to go ahead and approach the podium, state your name and your affiliation. It says you're representing or speaking on behalf of Native Sun News, and you have 3 minutes.
Thank you. My name is Jackie Gallego. I am owner, general manager of Native Sun News, along with my husband, Tim. We have had the city minutes for this last year. We would like to continue them on for the next couple of years so that we are informing our readers that are Native American to bridge that gap in the community with over 10,000 Native Americans that live here in Rapid City. So on what we wanted to do was to keep the rates what they are, which is the 15 cents, which has been that way. We wouldn't do any increase in that, but we wanted to project, instead of $40,000 that was put in the budget last year for us, which we were not aware of until it got canceled, we were thinking an estimate or a projected $16,000 for the minutes for the entire year. That may be a little bit tad over, because right now at half we have about $7,500 that is being paid for, but that also includes not the city minutes but also human resources from the different departments that have been coming in. And we know that with the job placement being with equal opportunity for Native Americans in this market is very important. So we would like to be included back into the budget for approximately $16,000. We would also like to have it for more than just 1 year, so we're not back negotiating on this basis.
Thank you. If any committee members have any questions when we get to item number 20, if you're available in the audience, that would be very much appreciated.
Thank you.
Thank you. I have no other further public speaker request forms for non-consent items 18 through 26. Am I missing anyone? Seeing none, public comment is now closed. We'll move on to item number 18. Item number 18 is the introduction and first reading of ordinance number 6070, an ordinance reclassifying the executive assistant program coordinator within the mayor's office, so the position is no longer an officer of the city, by repealing section 2.12.070 of the Rapid City Municipal Code. Got a motion by Lewis to approve, second by Nordstrom. Any further discussion? Seeing none, all in favor? Aye. Any opposed? Motion carries. Item number 19 has been moved to be treated after item number 25, so we're going to now move to item number 20. Item number 20 is the introduction and first reading of ordinance number 6069 regarding the appropriation number 1 for the 2016 budget. I've got a motion by Lewis to approve, a second by Nordstrom. Chair recognizes Alderwoman Drew.
Oh, gosh, nice. I just spilled my coffee. Jackie, could I have a couple questions for you, please?
Yes, ma'am.
Yeah, so when we're talking about this, is this, you're just printing the minutes for that cost, or is there other things involved in, that you print for the city?
What we did for the minutes so far this year, and I did give that as a introductory, oh no, I picked up my wrong thing. We've got about $7,500, which is minutes and the actual job placements. Job placements is around 2,000, so city minutes is about 3,000. In the city minutes, because we are a weekly and not a daily, one of the things we have not been printing is any RFP or any bids that are on the roster that needs to be immediate action, which of course the Rapid City Journal would handle on that daily basis. Because we come out once a week on Wednesdays, and then it's Wednesday to Wednesday, that we would then have the rest of the minutes what's in there. When the minutes have been sent to me, our deadline is Friday. Sometimes the minutes don't get to us till Monday morning. So depending upon pagination of the paper, sometimes they go in the week after. But so far, I have not been told that that was a problem. Matter of fact, I've been told to publish them as needed. So what I'd really like to do is get that on a weekly basis after the council members have met, to have them in on a Friday afternoon if possible, so that we can at least plan the pagination of the paper on Friday, which is our goal because we do print on Tuesdays.
Yeah. Just one more question. Do you get a sense that your readers really appreciate the printing of the minutes, that they read them, that this is something
They
they follow?
read them, and it's one of these that it's educating the Native Americans to what's going on into this market, their community, their home base. They live here, they buy groceries here, they have children that go to school here, grandchildren. So we've already been told by the elders that now that the minutes are there, they feel that they're part of the community, which they didn't feel that they were from before. So yes, we are getting positive feedback.
Well, as of our meeting last night, I think that Pauline Sumption has added this to a list that we'll review when we are looking at the financials for 2016. So thank you for answering those questions.
Chair recognizes the Finance Director, Pauline Sumption.
Thank you, Madam Chair. I just want to clarify that comment about how she doesn't get the minutes until Monday after the meeting. We are not required. State law dictates when we have to have our minutes to our legal paper, which is 7 days after the meeting, and that is the requirement that we fulfill. So if we were to get them to her anytime sooner, that would require overtime, which I am not willing to pay. And I've tried to explain this to Ms. Gallego many times, as did Charlene. So the timing of it, because they are not our legal newspaper, they get it just the same as when we do give it to our legal newspaper. State statute then says that the newspapers have 30 days to publish it after they receive it from us. So once they have it, it just has to get published in the next 30 days. We honestly don't care when, whether it's the Native Son News or the Rapid City Journal. They have 30 days. You know, the legal paper, the Rapid City Journal, has 30 days to publish it. Also, a couple other little clarifications. There is no discussion about pulling any of the HR items where we have job postings. That discussion is not happening. We are still planning on posting those as appropriate in all of our typical places that we publish job postings. As far as the bids and public notices in that respect, we do publish notices for our elections. Those will continue. We do not publish notices per se if we have a zoning variance, because we have typically, by the time we have to publish them in our legal newspaper, there's also a state statute on the requirements of when those publications have to happen. They are not part of the minutes. They are separate notices. They have never been part of the minutes, nor will they ever be part of the minutes. We are required to have separate notices for those public hearing type items. So those will probably continue to be the way they always have. The Native Son News gets our minutes in full except for the bill list. That's the only thing that we do not send to them. All other portions of our minutes do get sent, the same as the Rapid City Journal. So I just want to make those clarifications.
Thank you. Chair recognizes Alderman Lewis. Alderman Lewis is bypassing. Prior to, I believe we do have a motion and a second on this, but prior to the vote, I would like to relay some other information, and one of them is a personal observation or a personal concern. I do have a concern because I do get the Native Son News, and I have also been talking with the mayor, Mayor Allender, and he has recommended, since he's presented his budget, that publication line item in the 2016 budget should be reviewed by the committee members or the council members to allocate some of the money in order to handle the continued publication and education of our Native American population through the Native Son News. My concern is that, and I have this with any media source, and I have addressed it with other media sources in the past as well. In the last couple weeks, the Native Son News has run some very contentious articles, basically almost stating that Mayor Allender purposely cut the money from the Native Son News as a retaliation for not having support in the community for the election. When I read it, I try to view it that it is more of an editorial or a personal opinion of the person writing the article, but the way the newspaper is outlined, it almost seems like it's a fact distributing story. And I do not, from my personal experience with all the information regarding the election, as well as the finance budget that was proposed by Mayor Allender, those two stories over the last 2 weeks are not factual, and it was not a personal retaliation against the Native Son News to reduce that budget line item. To be perfectly frank, if I was of a retaliation mode or for part of my makeup, I would almost say no to the state of Native Son News because of those two articles of not being very factual or in my opinion, very fair. But I will reiterate, the reason I voted for the financing to the Native Son News in the first place was to further the education of the population within our region as well as our city, because I do believe communication is the highest form of making sure that we get many viewpoints coming forward so that we can make the best decisions as a city council. And so I do believe that the financing for the Native Son News needs to be there to further the education. But I did want to make sure that my comments were heard, because I have addressed other media that when it appears that a story is being written or presented as factual, and I know for a fact the facts contained or presented in it are not factual, I get very, very concerned. So, thank you. Chair recognizes Alderman Lewis.
Thank you, Madam Chair. I wasn't going to jump into this, but since we've started going down that road, I just want to point out that we're talking circulation numbers here. In my personal opinions, I think it's for $16,000. I'd rather see that money go to the Humane Society, which serves the entire community. And we're talking 813 or something like that. It's the Native Son News' weekly numbers, as opposed to like 9,000 to 10,000 daily from the Rapid City Journal. I don't think it serves the taxpayers very well, purely from a fiscal standpoint. Not to mention, I have major issues with the idea that everything has to be published in a paper anyway. I don't know how many people actually read the newspaper, or for that matter, the legal part of the newspaper that's under the age of 90. But I think that's, personally, I don't really see a big benefit to putting in the newspaper anymore. I think it's just ridiculous in this day and age of all the online resources we have. I know it's a state law, so our hands are tied, but I don't see any reason to throw good money after bad. So anyway, that's my opinion on that. And obviously there's no actionable item here, but when it comes up for further discussion, I definitely will not be supporting that going forward. Thank you.
Thank you. We've taken a little bit of leeway, but based on the public comment speaker addressing a budgetary request for the 2016 budget, the current budget item number 20 that's being presented is based on the presentation of the mayors to the city councils. No changes for this first reading have been initiated because the city council has not had any discussion on that. We have just simply sat through presentations at this point. So also with that, seeing no further lights, I just wanted on record why I'm voting no. I cannot sanction sending something to council that I do not agree with, and I know that there will be changes to this budget, so I will be voting no for that reason. I cannot sanction sending something to the full city council and saying that I approve of something that I know I don't. So there will be changes. Thank you. Seeing no further lights, all in favor?
Aye.
Any opposed? Aye. Motion 20 is done. Or agenda item number 20 is done. On to item number 21. Item number 21 is the introduction and first reading of Ordinance 6049 to amend provisions in the International Residential Code to address fire protection of floors by amending Section 15.13.280 of the Rapid City Municipal Code.
Second.
I've got a motion by Lewis to deny, second by Drew. Chair recognizes Tim Billings from the Fire Department.
Thank you very much, and thank you to the committee for the time that's been put into this particular item, and I'll keep my comments short today. So, just as a follow-up to our meeting on the 15th of July, which staff was directed at that time to try to come up with other concessions within the code that could be identified to offset the potential cost of this fire protection of the floor system. With that, Brad Solon had forwarded a memorandum earlier this week regarding the status of that. We didn't find anything beyond what had already been discovered through the building code committee that worked through the adoption of the International Residential Code as it is. There's 12 items that have already been addressed out of that, and we didn't find anything beyond that that was obviously, I guess, available to us to amend. With that, I also reached out once again to the home builders, Black Hills Home Builders Group, and specifically Mr. Loggy, to look for the list of items that we could consider. Understanding that there potentially was a list that is available that was causing the group some grief, and we had no input from that group regarding that, with the exception of one electrical item, which is not under our purview. Unfortunately, that's from the state. So with that today, you've heard all of the fire department's testimony in the past, and I would urge you to pass this today. I do not believe it's in our best interest as a city to reduce the minimums below the minimums, and would encourage you to support this item as previously requested. And with that, thank you.
Thank you. Chair recognizes Alderman Nordstrom.
Thank you, Madam Chair. I'm going to be voting against the denial and support the staff on this, primarily because I believe from the employees' point of view that have to go out and fight these fires, we need to give them all the protection we can afford to give them. And then I see this as primarily the examples were given to us in the past, and I don't need to repeat them all, but when the firefighters are going out to these sites, and seeing the conditions that they have, they need those abilities to fight those fires. Without this ordinance in place here, this just handicaps our fire department in another area. So I'll be voting no based on that and some other reasons. Thank you.
Chair recognizes Alderman Laurenti.
Thank you, Chair. And I also will not support the denial. I think it makes complete sense. But what disturbs me the most, I think, about this particular issue is that the fire department has bent over backwards, one, already making concessions, and we're at the bare minimum per the international code. But to ask for input from a home builders association, a professional group, not individuals, but the home builders association, who apparently, and I'll just read the words here from this letter, in my opinion, this is from the fire department, their lack of input or contact shows that they either do not have specifics or simply do not care at this point in the process. So, I mean, it's disturbing to me because it goes to the communication thing that you just talked about. It's one thing to disagree, and another thing to have zero input, to walk away from it, provide no input, and expect some sort of compromise, or maybe no compromise, but compromise surely won't happen when communication doesn't happen. So I think it's unfortunate that we're in this particular square, if you will, on this particular important issue for public safety. I would think from a public safety perspective, the Home Builders Association would at least come to the table and provide a list of areas that the city and the building code could look at to see if there is some room where we can make some sort of offset, as I've always been trying to fight for in this particular issue. But it appears, and in my opinion, I would urge my colleagues to pass it. I know the motion on the floor is deny, but the fact of the matter is, without any input from the home builders, it's amazing that we're going to support them walking away from the table and providing no input for some sort of compromise. Thank you.
Chair recognizes Alderman Lewis.
Thank you, Madam Chair. As a matter of factual statement, I think the home builder's been to every single meeting we've had. Jeff Logge's been to all these meetings. He's spoken quite ad nauseum about this part of the code, and and they've met with Tim Billings on the side, and I believe Jeff's last comment to me about this was he talked to Tim and said, "What are we going to talk about? We haven't talked about it. Let's just go have a beer," because they've met several times, and when it comes to compromises in the code, the problem is that the fire code and the requirements of the fire code have nothing to do with the building side of the code. So the things that cost builders money, like wind shear and things like that, have nothing to do with the fire safety part of it. You can't take out draft stop blocks. I mean, that's not going to happen. That's part of the building code anyway. So, and as far as just being the minimum requirement, well, the way the building codes get put together is it's put together by lobbyists, basically, and it's all, everybody goes in the room, comes out, and a lot of it's industry people who have money on the table, and they decide what's going in that code, and the home builders does their best to fight to get it down to what the manageable and affordable costs for the public. But to say it's at minimal code, well, yeah, I guess that depends on your point of view. But as far as the home builders not willing to compromise or talk about this, they've talked ad nauseum about the soils compromise, which we've come up with here again, and they have talked about this. Unfortunately, there's just no real hardcore things that can be taken out of the code. I mean, you can't just walk in and start arbitrarily pulling things out of the code that you don't like just because you want to have a cost savings with this potential cost here. And as far as this potential cost goes, once again, you're not talking about just sheetrocking a ceiling here. You're talking about roughing in a ceiling too for things like electrical, HVAC, plumbing that have to go in. If you're otherwise just going to tear that sheetrock out in a year or two when you go to remodel the basement. And so and that's a lot more money than just $1,000 or $2,000. You're talking about significant costs when you go and put the whole plumbing system in for the basement or the electrical system in. And once again, I think the home builders, Mr. Logge, have done a good job, in my opinion, of stepping up and trying to compromise as much as possible in this. And in full disclosure, I used to be a member of the home builders. I used to be the president. I'm not a member of the organization any longer, and I'm no longer associated with them. However, I do respect what they're trying to do, and they are really trying to keep affordable housing affordable, because it's not easy, folks. Believe me, there's constant requirements coming down from all forms of government and financing, and not just this particular one. But if you think that it's easy to just say, well, it only costs $2,000, well, that's $2,000 right out of the home builder's profit, because they can't just arbitrarily raise their prices $2,000. That doesn't work that way. The market dictates what you can charge for a house. It's not, you can't get every dime back unless you're doing a special, then you're doing a special build for somebody, then you can build into your cost. But otherwise, just walk up and add $2,000 to a $199,000 house does not become a $201,000 house overnight because we put a new requirement in there. It doesn't happen. The market doesn't work that way, and I just think I've been very supportive of the fire department, and Weifenbach and I actually agree on something, is that we're not anti-fire department because we're speaking against this particular code. I've gone on my way to support the firefighters. However, in this case, I just cannot do it. Thank you.
Chair recognizes Alderwoman Drew.
Thank you, Madam Chair. I agree with Alderman Lewis on this. I do think that we have talked about it ad nauseum, and the home builders have come to the table. As we learned last night, we really would probably get a lot more out of hiring more firefighters in an effort to save structures. And I don't see that this is going to be what will meet our needs, and it'll just be another hurdle for the home builders. So I'm going to vote to deny.
Chair recognizes Alderman Laurenti.
Do we have somebody here from Home Builders? If you could come to the podium, please. I just want to make a clarification. It appears we don't have the support, but I want to clarify something. I want to get it on the record. We can, if you can, Tim, when did I'm trying to remember when we...
If I can just interrupt, would you please identify yourselves,
Go ahead.
and then Alderman Laurenti will address his questions to you.
I'm Jay Mendel, president of the Black Hills Home Builder Association.
Jake? Did you say your name was Jake?
Jay Mendel.
Jay, okay.
Dane Boomsma, and I'm the first vice president of Black Hills Home Builders.
Thank you, gentlemen. Alderman Laurenti, you still have the floor.
Thank you. And if I can, I'd like to ask a question of the fire department here and get some clarification, because we continued this at the last, was it the last Legal and Finance meeting or the one before? Was it a month, Tim?
Right, it was a month ago. It was
Okay.
July 15th.
So, and now I'm going to ask home builders this question. Since that time, has the Home Builders Association met with the fire department?
It's my understanding that Jeff Loggy talked to Tim, and they both pretty much agreed they're at a standstill. They weren't willing to come, and we weren't willing to come, and that was the last, as far as I know, my understanding is.
Okay, so for the fire department, again, has the home builders met with you, sir, to talk about any other areas of the building code that might be able to offset what we're trying to do here from a public safety standpoint, since that last continuation a month ago?
Since the last continuation, no, we haven't. Jeff and I spoke on the phone one time while they were going to state convention, I believe, which I don't remember if that was before or just after the last meeting. And at that time, we discussed the fact of trying to develop a list. Jeff had some frustrations of didn't know if he could do that, where we were at with it, and that's the last we've heard. I've had my administrative assistant call several times to the office to try to make arrangements, and I've also left a message with Jeff more recently to try to once again get together. Dane and I visited yesterday morning just briefly following the building code meeting, but not specifically regarding independent items. So.
Okay, thank you very much. I yield.
Chair recognizes Alderman Nordstrom.
Thank you, Madam Chair. Gentlemen, Jay and Dane, thank you for coming in today. Appreciate your attendance. If you can correct some information or make sure I've got the data correct, I've been visiting with the county equalization people over there, and they're telling me that most of the new construction that's coming in, the people are already doing the rough-ins. Am I getting accurate information here?
The underground rough-ins for a future bathroom in a basement are done. The in-floor rough-ins are not done. Typically, when you have an unfinished basement, you have a light at the bottom of the stairs, and then there's one switch that switches all the remainder of the lights in the basement. None of the HVAC is installed in the basement other than the minimum needed just to maintain, a moderate climate down there. So the electrical and the mechanical are not completed to finish the basement.
Sure, and that's true with any unfinished, but correct me if I'm hearing the data wrong again, is that when people do install it, and again, going back to the Department of Equalization, they're telling me about a third of the new houses are doing this. But it is when they're doing all of these rough-ins, just the walls and the ceiling now, putting it in the basement specifically. Are they really coming in a year and two later and tearing that out and finishing it?
Are you saying that there's a third of them already being sheetrocked, even though it's an unfinished basement? Is that what you're saying?
That's what the Department of Equalization is telling me.
That is not correct. Now, I did hear a stat yesterday, I believe from Brad, that said, I think it was actually you that said it, but got it from Brad, was that only 40% of the houses are being permitted with unfinished basements. Is that correct?
That's right. That's the
So to date, in the city of Rapid City, we already have 60% of them that are meeting this minimum fire code. We have 40% of them that aren't being finished because the people can't afford to be finished. And they're unfinished for an undisclosed amount of time. It may be a long time. More than likely, half of those are going to be finished within the first few years because the people are using sweat equity to do that themselves. So now we're down roughly 20% of homes being built maybe not have a fire floor protection. So I agree that this is fire safety, but in my opinion as a home builder, it just does not make sense because of the costs involved that is not benefited from when you do finish the basement.
But is it really taking a year or two and then they're tearing it all out and actually finishing it?
We're not currently doing this. This doesn't happen. We don't sheetrock the ceilings unless it's a finished basement. This code would require us to finish or to sheetrock the ceiling, even though it doesn't require us to install the mechanical or the electrical or any plumbing to finish it later. That's why the sheetrock will be torn down when the individual homeowner decides to finish the basement. Does that make sense?
It's not quite in getting to my answer, but thank you. I'll leave it there.
Chair recognizes the Fire Department, Mr. Tim Billings.
Just a quick clarification. We've tended to drift towards focusing on just the sheetrock application. There's a number of other options that are available to do that, that would not require the installation and then removal of sheetrock. It's whether it's with the floor truss assembly is protected, whether it's the basement is provided with a fire sprinkler protection, whether it's dimensional lumber. I mean, there's a number of ways that it would not have to be sheetrock. So I don't want us to get focused just on the sheetrock that's going to have to be removed. There's other options. And obviously they do come with some cost associated, but I just didn't want us to get tangled up in one piece of it, so.
Can I make a comment, Madam? Sure.
I believe you would have to have a question. Chair recognizes Alderman Lewis.
Mr. Broomsbaugh, do you have a comment you'd like to make?
I just have a comment to Tim. There's not an option that I have seen to meet this code that could be saved later in the basement finish. All of the options that I have seen presented by the fire department, and the fire department has gone above and beyond doing their research, and I commend Tim for that. But all of the options have no cost, benefit, or savings when that basement is finished. That is why, from a builder perspective and affordable housing and the reality of what this causes, is why I still remain opposed to the ordinance.
Alderman Lewis, you still have the floor.
I guess I would just add that, things like putting a sprinkler system in is admirable, and of course I've done it on a few houses now just because I have to, but I have the one subdivision in town that requires it. But the fact of the matter is that's like $2 a square foot or better, so you're actually more expensive in the long run. And I just think that, this is obviously just an issue where we're both going to argue our cases. It doesn't matter if you agree or don't. I mean, you're going to vote however you want to vote, but I can tell you from a perspective of coming from the industry that it's cost prohibitive. It really is. And these guys have done a pretty good job of letting us, run with a lot of, Mr. Broomsbaugh supports something I don't support, and that's the expensive soils over excavation all the time, for different reasons, but that's a very expensive thing to do. So he's obviously for doing the right thing. I think in this case he sees the benefit not being directly there. So I think it's, just in the interest of pointing out the fact that they're not against everything we try to put up here. They're obviously they're very proactive on the expansive soils thing, which is a very expensive thing to do to a house. And this is just one more issue that they've decided, if this really was that could be that much of a benefit, they'd do it. But I think in this case, they've stepped up and drawn a line. Thank you.
Seeing no further discussion, I currently have a motion on the floor to deny item number 21. The recommendation going to City Council Monday night would be to deny, dependent on the vote. And as you'll find out in the vote, I'm going to go ahead and support the denial for my own vote. Seeing no further discussion, all in favor of the denial? Aye. Aye. Any opposed? Aye. We have 2 in opposition, Alderman Nordstrom and Alderman Laurenti. Recommendation to City Council Monday night is for denial of item number 21. We're on to item number 22, second reading and recommendation of ordinance number 6050 to amend provisions in the International Residential Code to address compressible, shifting, and expansive soils by amending Chapter 15.13 of the Rapid City Municipal Code. Chair recognizes Alderman Nordstrom.
And I'll second that motion.
I've got a motion by Laurenti to approve, second by Nordstrom. Alderman Nordstrom, you have the floor.
Thank you, Madam Chair. I just wanted to extend my compliments and gratitude for the home builders to coming forward with even the soils people, engineers specifically, coming forward and coming up with a compromise, and it's actually workable. So thanks, gentlemen, for doing what you're part of it, and and please pass along my gratitude to the soils engineers too. Thanks.
Chair recognizes Alderman Lewis.
Just want to echo Mr. Nordstrom's comments. I think it's obviously something that's beneficial to the citizens as a whole. I don't necessarily agree with all the implementations of it, but I do understand the process that needs to be done. We need to do something, and once again, I appreciate the home builders stepping up to the plate and being very proactive and very responsive in this case. Thank you.
Chair recognizes Alderman Laurenti.
Thank you, Chair. And I just wanted to reiterate, and I think I said it before, but in this particular issue, and I'm glad the home builders was on board with it as well, but there's definitely, there's a lot of litigation going on today. We all know this, and the home builders know it, and developers know it. The fact of the matter is, this is going to provide some protection, hopefully, hopefully reduce some of the people who have completely lost their homes because of this expansive soils issue, who are now suing builders and developers. So ideally, hopefully, doing this, it's going to help provide protection for all, especially developers and home builders, so that when they're buying a plot of land, they can assess the expansive soil situation and decide whether they're going to buy that particular piece of land and develop it in the first place. But it provides some legal protection for home builders and developers who do the right things that these engineers say they need to do in expansive soil situations. And they do those things. It's going to provide some shield to litigation. So this one it makes complete sense, and I'm glad that all the parties have come together, and it's taken quite a while, but I think we have a good ordinance, so thank you.
Chair recognizes Alderwoman Drew.
Thank you, Chairwoman. It really has taken a long time, and we were discussing this earlier. That's good when government moves slow, that things are taken into account and really assessed for what the benefit will be. But I do have a question, and maybe this goes to Carla. Who is responsible at the end of the day for the content of the soil? Is it the engineer, the developer, the home builders? I mean, who's on the line when we have a reading that's not appropriate for home building?
Well, the ordinance requires a geotechnical engineer to make an evaluation initially for the builders, for the builder, and that needs to be provided to the city as a check to make sure that it occurs. And then the ordinance reads that once before the project can be completed from the city's perspective, that the permit holder, which would be the builder, has to complete an affidavit that any recommendations in the geotechnical evaluation were done, that the builder did it. And, I think today, under the code today, the obligation is on the builder to take care of the soil, to, just like the remainder of the items in the residential code, it's the builder's obligation or the contractor's obligation. This would be no different. So the protections in the ordinance are to ensure that they get professional advice on the soil and that they submit an affidavit that they did what they were advised to do.
Just one second. Carla, would you please identify yourself and your affiliation of the city, please?
Carla Cushman, Assistant City Attorney.
Thank you. Alderwoman Drew, you still have the floor.
So just so that I'm clear on this, so it still goes to the home builder to be responsible for any damage and, soil shifting, those kinds of things?
I think so. I mean, from a legal perspective, there's some liability on the geotechnical engineer. I mean, if they are totally off base and give them bad advice, there's liability there. But that's not really something that the city supervises or would manage. But just like the remainder of the obligations in the residential code, of which there are thousands probably, it's ultimately the builder's responsibility to make sure those are complied with. And they do a good job of doing that.
Besides the affidavit, is this any part of the building permit?
They need to provide the geotechnical evaluation at the time of the footing inspection. So that's after they get the permit, but early on in the process. And they just need to complete the affidavit if it's appropriate by the time they get the final inspection.
Well, I've taken a lot of time with this particular ordinance, and I'm going to vote in favor. So thank you for taking time and answering the questions.
Yes.
Chair recognizes Alderman Lewis.
Thank you, Madam Chair. And if I might address what I think Darla Drew is trying to get to is, I would guess you're going to see most purchase agreements written on property from now on contingent upon soil approval by the builder. Just a guess, wild one, but if I'm buying something, that's what I'm doing. Letting you know.
Thank you. Seeing no further lights, I do have a motion to approve in a second. All in favor? Aye. Any opposed? Motion carries. Item number 23 is a second reading and recommendation of ordinance number 6032 to promote historic preservation by repealing Chapter 2.68 of the Rapid City Municipal Code and adopting provisions in Chapter 17.04 and 17.54 of the Rapid City Municipal Code.
Move to approve.
Got a motion by Nordstrom to approve, second by Laurenti. Any further discussion? Seeing none, all in favor? Aye. Any opposed? Motion carries. Item number 24 is the second reading and recommendation of ordinance number 6064 to amend provisions concerning consolidation plats and lot line adjustment plats by amending section 16.08.100 of the Rapid City Municipal Code. Got a motion by Drew to approve, second by Lewis. Any discussion? Seeing none, all in favor? Aye. Any opposed? Motion carries. Item number 25 is to authorize the mayor and finance officer to sign the professional services agreement with Progressive Urban Management Associates for the downtown area master plan in an amount not to exceed $197,450. The chair would like to recognize Mr. Limbaugh to go ahead and give us a rundown, Mr. Limbaugh, on the financial request of this item and the different funding sources, please.
Thank you, Madam Chair. We have assembled approximately $97,000 towards this study in this year. $60,000 of that is coming from the downtown bid. Another $17,000 of that is coming from Destination Rapid City, and that's part of a Bush grant. And then our office, CPDS, has $20,000 that we've contributed towards this project this year. The contract amount is for $197,000, so the gap financing that we need is $100,000 to complete this study. The study will take approximately 10 months, so we'll be starting off in September and going through into next year. If we are able to get the additional $100,000 on the subsequent item that you'll be looking at today, we will be able to go ahead and execute the contract and get our consultant moving forward.
And thank you. And Mr. Limbaugh, the request for the $100,000 in order to put this out for contract is recommended to come out of general fund undesignated cash?
I believe that's probably the best source, and if the finance officer concurs, and it looks like she does, then that's what I would recommend.
Okay. So just so the committee members understand, item number 25 in its totality is requesting, has funding sources for everything except $100,000. The City Council is being requested to go ahead and authorize $100,000 out of the general fund undesignated cash in order to move forward with item number 25. Seeing that, I'll entertain a motion by any or discussion. I've got a motion by Alderman Nordstrom to approve item number 25, a second by Alderwoman Drew. Any further discussion? Seeing none, all in favor? Any opposed? Motion carries. Now on to item number 19. The reason we moved item number 19 to after item number 25 is this is the introduction and first reading of ordinance number 6068 regarding the supplemental appropriation number 3 for the 2015 budget. The $100,000 that was just approved by this committee from the undesignated cash for item number 25 is included in this. I've got a motion by Laurenti to approve item number 19, a second by Nordstrom. Any further discussion? Seeing none, all in favor? Aye. Any opposed? Motion carries. Item number 26 is the request for the final determination relative to the proposed siding replacement affecting a residential historic property located at 703 11th Street. Chair recognizes Alderman Nordstrom.
Thank you, Madam Chair. Make the motion to approve with a option number 1, final determination that there are no feasible and prudent alternatives and that all possible planning to minimize the harm to historic property has occurred. This finding authorizes staff to process the building permit pursuant 1-19A-11.1 of the South Dakota Codified Laws, SDCL, and then also include stipulations included on the staff memo, primarily from page 2. That's my motion.
So I believe the motion condensed is to approve option number 1.
With stipulations.
With stipulations. And then just for clarification, Alderman Nordstrom, you're making this motion on option number 1, even though according to SHPO it may cause, I'm trying to look for the words, I just had it. Non-contributing factors, correct?
Let's go to Sarah Hensel for clarification, and Sarah, if you identify yourself. Thank you.
Yes, Sarah Hansel, Long Range Planner, Community Planning and Development Services. The State Historic Preservation Office, the SHPO, has reviewed this project, and because of the nature of the project to remove original siding to the home, it is considered an adverse effect. However, the applicant has done due diligence in looking into alternatives. The Historic Preservation Commission also reviewed those alternatives and recommends approval of the projects with the stipulation. So it is an adverse effect, but we've done all possible planning to minimize the adverse effect.
Alderman Nordstrom, you still have the floor?
Thank you, Madam Chair. I was just going to pull up the stipulations, and I think they're pretty clear as to what those requirements are. I don't have them in front of me right now, but
That's okay, it's part of the motion you made.
And I think that really helps clarify what we're after, and especially the Historic Preservation Commission is trying to attempt to do on this as well. So with those stipulations, I don't see a problem after we get it going. Thank you.
And I did have a motion by Alderman Nordstrom for option number 1 with stipulations. Did I have a second? Laurenti? Any further discussion? All in favor? Aye. Any opposed? Motion carries. I'll entertain a motion to adjourn.
So moved. Second.
Got a motion by Laurenti to adjourn, second by Nordstrom. All in favor? Aye. Any opposed? We're adjourned. Thank you, everyone.